If you want my hottest of hot takes on the Supreme Court, I'm opposed to live broadcasts of the Supreme Court. In fact, I don't think there should be cameras in the United States Congress. It allows for performance art. You have the people in the cameras performing for their constituents at home, and it's just absurd. Congressional hearings are now all about playing to the cameras, not actually about meaningful decision-making by Congress. It's why you get to where we are now with Alexandria Ocasio-Cortez, Ilhan Omar, Marjorie Taylor Greene, Lauren Boebert, and the like. They're playing for the crowd on the cameras. They're not actually legislating. None of them are very accomplished in legislation. And don't say that those Republican members can't get things done, because some members of the House Freedom Caucus were able to persuade the Democrats to do things with PPP and improve the situation for people whose businesses were shut down because of COVID, but not them. They're too busy pandering to the base nationally instead of actually doing work for their constituents, Democrats and Republicans alike. I think cameras in the courtroom would allow performance art. We got a taste of that with Sonia Sotomayor today in the audio, the live stream audio, where she essentially was filibustering on behalf of Planned Parenthood. She was just reading talking points. She was barely asking any questions. She is not the brightest justice, and it is actually well known in legal circles. And in fact, the leaked documents from the Obama administration showed that a lot of people within the progressive legal community were begging Barack Obama not to pick her because she was too combative as a judge and not very bright. And he picked her because he was trying to pick up the Hispanic vote. It was entirely a play based on demographic politics, not on who would be the best justice. It played out today where she largely undermined her case, comparing a fetus to a brain-dead person. If I had to call it, and you actually learn very little from the oral arguments, what you need to understand about these cases, particularly this case, you need to understand something. This was not a case where the lawyers were trying to persuade the United States Supreme Court. You gotta, philosophically, if you go back and you listen to the audio, what you need to understand is that what happened for the last 2 hours in the United States Supreme Court was not lawyers trying to persuade the Supreme Court to go in their direction. It was the justices having a conversation amongst themselves through the lawyers, trying to persuade each other. You saw, for example, Chief Justice John Roberts throwing out a standard other than viability. John Roberts very clearly does not think that Casey and Roe are good law. But John Roberts also very clearly does not want to overrule and reverse Casey and Roe. Casey and Roe together set a standard for abortion on viability. With Roe, it was the 3 trimesters. Casey modified it to the point of viability. The problem for abortion advocates is that viability has moved back earlier and earlier and earlier, from 26 weeks to 25 weeks, 24 weeks to 23 weeks, 22. Now it is not unheard of to get a 21-week preemie who can survive. So the viability standard keeps moving because of the science. So John Roberts' argument on moving viability to some other standard makes sense if you want to upend Roe without also reversing Roe. Amy Coney Barrett, and by the way, I'm not dealing with Sotomayor, Breyer, and Kagan because they very clearly don't want to do anything. Most interesting to me was how silent Kagan was in the arguments today. Kagan knows the left has a problem. The votes are there to end Roe and Casey. What Kagan did in the entire oral argument herself was to, through the lawyers, have a conversation with Brett Kavanaugh and John Roberts. Roberts about the viability standard and why the standard he wants wouldn't work, and with Kavanaugh, why his concerns about stare decisis were misplaced. Now, for those of you who want to know stare decisis real quick, stare decisis is for suckers, as a friend of mine would say. Stare decisis means you go with the precedents of the court. You don't just upend the precedents of the court. It took the court 50 years to overrule Plessy versus Ferguson, not because the court didn't realize it hadn't made a mistake, but because it needed to do so gradually to upend Plessy versus Ferguson. It just does not like to overrule itself or reverse itself because of its credibility. So Sotomayor the entire time was screaming about the court's credibility. Breyer about stare decisis, and Kagan about stare decisis and viability. That suggests to me in their line of arguments they know that the 6 members of the court's majority intend to take action against abortion. But what is that actually going to be? Clarence Thomas and Sam Alito very clearly want to kill Roe and Casey. Neil Gorsuch, it seems, is with them on that he just thinks it's bad law. He doesn't care about abortion. He just thinks Casey and Roe are terribly, terribly decided cases. And frankly, even Ruth Bader Ginsburg agreed with them on that. Kavanaugh is interesting because Kavanaugh thinks that the court taking a position on abortion makes the court not a neutral arbiter on what is, for all intents and purposes, a moral decision. The court repeatedly wanted to rely on secular jurisprudence and secular scientists, and Kavanaugh was really having none of it there, saying, that there are secular people who also believe that life begins at conception. Science itself says life of some kind begins at conception. If we think that the prior precedents of Roe and Casey are seriously wrong, if that, why then doesn't the history of this court's practice suggest that the right answer is to return to the position of neutrality? That's Kavanaugh. It sounds very much like Kavanaugh wants to get rid of the court's dealings with abortion. So really you have Chief Justice Roberts, whose wife is a pro-life activist, who clearly wants to get rid of the standard of Casey and Roe. That his entire line of questioning was on the viability standard. And what should they do to reduce the viability standard without getting rid of Roe and Casey? So you've already got him wanting to reduce the role of Roe and Casey. You have Alito, Gorsuch, and Thomas, who clearly are just ready to scrap it. You have Kavanaugh, who seems like he too is in that camp. So that's Kavanaugh, Alito, Thomas, and Gorsuch. That's 4. You need one more vote. Enter Amy Coney Barrett. One of the big arguments in Casey and Roe is that it's about the parenthood interest. It's not a pregnancy interest. It's a parenthood interest. And Barrett actually picked up on this. It's something that a lot of opponents and advocates of abortion miss, that the Casey-Roe standard there is a parenthood interest, not a pregnancy interest, that some people have no interest in parenthood and should have the right to terminate the pregnancy prior to viability to avoid being burdened by the obligations of parenthood. And Barrett hit on the fact that adoption is now so widespread, and you can even adopt a fetus that survives abortion that is injured. You can immediately promptly adopt that in many states. Barrett's was very intriguing because she wanted to separate pregnancy and parenthood, and that suggests to me that what Amy Coney Barrett wants to do is to get rid of Roe as minimally as possible. And by that I mean, if you just with a broad brush get rid of Casey and Roe, there are a lot of legal precedents as well that begin to collapse. Unless you, depending on how you do it. And even with Clarence Thomas, you could tell, Clarence Thomas has no love lost with Obergefell, Lawrence v. Texas, things like that. The cases on, for example, sodomy and homosexual marriage and the like. He doesn't care about gay marriage or non-marital sexual relations between people of the same sex. He cared greatly at one point. The courts moved on. How do you get rid of Roe and Casey without also upending those cases? He talked about a lot about the liberty interest and the privacy interest. and then the interest of the other party. And there, I think, is where they line up. That the three liberal justices would have you forget that there is a third party involved in the matter. It's not just the male and the female who is pregnant, but the child as well. And Thomas has been fairly outspoken that he suggests the 14th Amendment would give legal protections to an unborn child. The other justices are not so far there. But Kavanaugh and Barrett and Gorsuch seem to recognize that you cannot ignore that the child is a living organism, and that living organism, because it is a human organism, is entitled to some level of protection, viable or not. If life begins at conception, there's a level of protection needed for that life who cannot itself argue in court. So that suggests to me, and again, oral arguments are a bad predictor of where we're headed, but in this case, keep in mind, this is unlike most oral arguments because you can't persuade these justices on the issue of abortion. You can't argue something that hasn't been argued before. So what this case became in oral arguments today was not a matter of lawyers trying to persuade the Supreme Court, but the Supreme Court justices in public having a conversation between themselves on where they should draw the line and how they should dispatch two cases. And the three justices of the left trying to convince them it would be bad to get rid of it altogether. The Chief Justice trying to convey that in the interest of the court, maybe they should get rid of it without getting rid of it. And the others trying to figure out exactly how do we get rid of it and minimize the fallout from so doing so that we're not constantly revisiting the issue. And three of those suggesting they don't care, just get rid of it. That suggests at least 5 members of the U.S. Supreme Court are right now behind closed doors preparing to eliminate Roe versus Wade and Casey versus Planned Parenthood.